Great. Okay. Welcome everyone to this first meeting of the Housing and Regeneration Scrutiny Panel for the new municipal year. I'm Matt White. I'm the chair of this panel. What I think we should do is, before we get going on the agenda, go around and introduce ourselves, so members of the public watching know who's here in the meeting. So, as I said, I'm Matt White. I'm a councillor for Tottenham Central. I chair the panel. Should we go? I'll go around to the left. So I'll start with you, Philip.
My name is Philip Slaughter. I am the scrutiny officer for the panel.
Councillor Mark Blake.
Good afternoon. I am Khaled Muid, Labour councillor for Knoll Park.
Hi, I'm Tammy, Labour councillor for St Anne's, and my first scrutiny meeting.
Great, and welcome. And obviously that's quite a few new members of the panel now. So quite a change to the membership from last year. Okay, we've also got with us, Councillor Carlin, could you introduce yourself?
I'm Councillor Dana Carlin. I'm the Cabinet Member for Housing, Private Renters and Planning.
Great, thank you very much, Dana. And Bryce and Rob, could you introduce yourselves, please?
Bryce Tubble, Interim Head of Planning Policy, Transport and Infrastructure.
And Rob Shastovsky, Assistant Director for Planning, Building Standards and Sustainability.
Great, thank you very much. And you'll be here to assist with the later items we've got on the local plan and community infrastructure levy. And I believe we've also got Lynn Seller online. Lynn, could you introduce yourself?
Yeah, I'm Lynn Seller. I'm currently the Acting Head of Regulatory Services.
Great, thank you very much. And Lynn will be helping us with the first two substantive items we've got on the private centre rental regulation and the empty homes policy, I believe. Thank you very much. Right. Just before we get going, I'd also just like to remind panel members that as councillors and as members of the council's scrutiny function, we're here to scrutinise decision making by the executive. So when it comes to decisions, it's and the kind of political side of stuff, it's really the cabinet member as decision maker that we should be directing our questions to. Officers are here to answer technical questions about the policies of the council and clarification on the reports, that kind of stuff. So just to be clear that what we're not here to do is kind of publicly scrutinise, publicly performance manage council officers. We're here as councillors, and we're here to scrutinise decision making by the council executive. So just a reminder. Okay, so item 1 on the agenda. This is just a reminder that this meeting is being filmed, it's being recorded, and it's being broadcast live on the council's website, and it's also be made available for subsequent broadcast. And also any members of the public that are here, although we have one member of the public effectively here, are able to record proceedings using any communication method. So just a kind of reminder that by being here, we can't guarantee that people won't be filmed or recorded by other people who attend the meeting. So people should be aware of that. And just a reminder that I have the discretion to terminate or suspend filming or recording if, in my opinion, continuation of the filming, recording or reporting would disrupt or prejudice the proceedings, infringe the rights of any individual, or may lead to a breach of legal obligation by the council. Okay, so apologies for absence. I believe we've had apologies from Councillor. We've had Councillor Ajay. I've just received apologies from Councillor Harrison Mullane, and also I believe David Joyce, the director, has extended his apologies for absence this evening. So thanks for those. Okay, urgent business. I don't believe we have any urgent business that's not on the pre-published agenda, so we can dispense with that item. Does anyone have any declarations of interest? I hear no declarations of interest, so let's move on. I don't believe we have any deputations, petitions, etc. this evening.
No, Chair.
Thank you very much. So, moving swiftly on, the next item is the minutes of the meeting on the 7th of March. As far as I can tell, I'm the only person here who was at that meeting on the 7th of March. I've already approved these minutes for inclusion in the papers for this evening. So unless anyone's got any objections, I hope we can just formally approve the minutes and move on. Okay, let's say that those minutes are approved. Right, okay, so our first substantive item this evening is the private sector landlord licensing scheme update, which is on pages 9 to 16 of the pack. Lynn, are you going to provide a little introduction of this item? And I'm sure members will have some questions for you following that.
Yes, yeah, that's fine. Yep, so we were asked to provide an update on the council's landlord licensing scheme. Just to put it into context, we've actually got a mandatory HMO licensing scheme that's been running since the legislation introduced it in 2006. But in addition to that, in 2019, we got cabinet approval to extend that particular scheme to smaller types of HMO. So they're known as additional houses and multiple occupation. That's a borough-wide scheme, and that became operational on the 28th of May in 2019. The scheme runs for 5 years. The landlords pay a licence fee, which is ring-fenced for the operational and enforcement costs of running the HMO licensing scheme. And as part of the licence process, we check and see whether the details that are provided regarding the ownership of the property is correct. We also check that the property licence holder is a fit and proper person. And then we go into checking the actual legal requirements of that particular property. It's then followed by an inspection, which we have to undertake within the 5-year period of the scheme, and any non-compliance with either the HMO licensing conditions or the wider legal standards around fire safety, etc., for those types of properties will be picked up. The landlord will be given a schedule of works. If they don't carry out those works within the specified time frame, then we're in a position to take enforcement action against the licence holder of the property. So the scheme is now in its 3rd year. There is statistics within the paper in terms of what we hope to achieve as part of the HMO licensing scheme and what we have actually achieved to date. There is a small caveat in the paper in that obviously COVID-19 pandemic did and has hindered some of our operational plans, in that we weren't allowed to enter people's premises. So that has impacted us on the ability to undertake compliance checks. So we're playing catch up a little bit now in our 3rd year around that. We've also recently put to Cabinet a proposal to introduce selective property licensing. So this would be for properties that are rented out to single families or to unrelated sharers. It covers an area within the east of the borough. This is a specific designation which falls in line with the legal requirements to introduce selective property licensing. Cabinet approved that in March, and our proposal has now gone to the Secretary of State for decision making, and we're still awaiting the outcome of that decision making process. And until such a time, we can't proceed with any of the implementation of that particular scheme. So I'm happy to take questions, or if somebody would like any further clarity.
Great, thank you very much, Lynn. Yeah, I've just got a couple of clarifications. So, I mean, I think I know the answers to these, but just for the record, 5.7, when we're looking at additional HMO licensing, it doesn't state this in the papers here. It talks about the designation makes it a legal requirement for any person operating an HMO within Haringey. It doesn't talk there about the definition of an HMO, but I think if you refer to 5.14, it says that the new selective licensing scheme will cover single family households or just two unrelated sharers. So am I right in thinking that an HMO is therefore defined as any property occupied by three or more people who aren't all related to each other?
That is absolutely correct.
Great. So yes.
Apologies, I should have perhaps put that in the paper. So yes, the legal definition for an HMO is property that's rented to three or more sharers that are unrelated. The actual mandatory definition is for larger types of HMOs, which are rented to five or more people who are not related, so they don't form a single household, where there's some form of sharing of an amenity. And the mandatory scheme was originally introduced by the government as a mandatory scheme because they were higher risk premises. And the additional scheme is an additional power that we can use as a local authority at our discretion. So not all local authorities will have an additional HMO licensing scheme.
That's great, thanks, Lynn. And of course, I'm actually quite familiar with this, having lived in HMOs for the vast majority of my 20-something years in Haringey. But just so all panel members are aware of that. And just leading on from that, obviously, currently, under the definition that we just discussed, anyone who rents that type of property needs to have a licence in Haringey. And what we're proposing to do, we're still waiting for the government's permission to do this effectively, is to extend the licensing scheme to all rented properties, but only in part of the borough. So what I'd just like to clarify with you is, why can we not do this for the whole borough?
Yeah, just because the legal requirement asks us to substantially evidence the need, and our evidential testing didn't provide substantial evidence that there was a need for interventions that come in through the selective licensing powers across all of the wards in the borough. So we spent nearly 2 years looking at data, and we commissioned data through MetaStreet, which specifically specialise in property data, along with our own council held data. And then we got that data scrutinised by experts who are have brought in selective licensing schemes for other local authorities. And along with that decision-making panel, we picked the area within the borough that we felt we would get the permission to have a selective licensing scheme for from the Secretary of State. So we've used learning from other local authorities who haven't been successful, along with obviously the intelligence that we had from our own borough demographics and data on the private rented sector stock.
Great, thank you very much for those clarifications. I'm going to throw it open to questions from other panel members now. So Councillor Moyd, I saw your hand go up first.
So Appendix A, which is appended to this report, it shows the map of the wards in Haringey, and there is a dark red line in the middle. So I'm assuming all the wards to the east of that is where we have the selective licensing. Is that right, first of all?
Yes, that is correct.
Yeah, okay. All right, thank you for that, because I mean, the map doesn't actually make it clear. That is. So what I wanted to understand is, you've got then in Appendix 2, all of the selective licensing objectives, which is great. I just wanted to understand in terms of enforcement powers, so that all the properties that will be licensed, what sanctions do we potentially have for any landlord that is not able to demonstrate that they meet these objectives that you've set out? And ultimately, will we have the power, I hope we will, of revoking someone's license so that they're not able to continue to be a persistent offender?
Yeah, so the benefit of having licensing is that the licence, that we've obviously looked into originally whether the licence holder should be a fit and proper person, and this is legally linked to any criminal convictions that the licence holder may previously have held that are unspent. And also whether they've had any previous convictions in terms of action that other teams and ourselves may have taken within the council. So all of that is checked. In terms of property compliance, so we will be inspecting those properties or the percentage of properties that we think we'll be able to inspect as part of the licensing scheme as part of the process. And anybody who doesn't meet the legal requirements in terms of property standard or throughout the duration of the scheme is not meeting the requirements of the licensing conditions, then we have powers to take enforcement action against those licence holders. So it will be in line with our enforcement policy, which is that we would be fair in the beginning and obviously give the person the opportunity to make those remedial actions, and then if they don't comply with that, there will be the issuing of enforcement notices, and then non-compliance with the enforcement notices could either result in a prosecution or we have now the ability to issue civil penalty notices on landlords who fail to comply with certain parts of the Housing Act, and that's more of a sort of stick in the sense that most landlords don't want to be issued with financial penalties, and we can issue a fine up to £30,000 depending on the nature of the offence, and that money is then ring-fenced to come back into the directorate for further resources for enforcement work essentially. So it's become a more desirable method for local authorities to penalise non-compliance through the use of civil penalty notices than through prosecution. But we can pick one or the other depending on the severity of the offence. It would be pointless using civil penalties against landlords who have had them in the past, for example, and haven't paid. So it doesn't become a penalty. So we would more likely prosecute a landlord under those circumstances. So those are the enforcement options available to us.
Thanks. Sorry, did you have a follow-up on that? And then I'll go to Councillor Hymas.
Yeah, just a quick follow-up. So you've talked a little bit about financial penalties. So penalty charge notices being issued to licence holders. Now, if I were cynical, I could say that's just another way of the council making money. If the penalty is not also complemented by certain action that the landlord has to take, the tenant is not really benefiting from this particular enforcement action. The landlord or the license holder could just cough up whatever the penalty is, but not take any remedial action. So are we envisaging that there will be an enforcement action where it's just a PCN that's issued, or can we be assured that the PCN will also have an element of remedial action that will have to be taken?
So the local authority won't be taking any remedial action on behalf of a landlord who fails to remedy any defects at a property. We don't have the powers to do that, and that's no different from whether we have selective licensing or property licensing or not. Unfortunately, the legislation doesn't stretch to that, but the and nor would a prosecution. So just because we prosecuted the landlord doesn't mean to say that he actually then goes and does the works at the property. But what it does mean is that if we take that action, then the landlord then doesn't become somebody who is deemed to be a fit and proper person, and therefore then wouldn't be able to be a licence holder, and they would have to find an alternative licence holder for that particular property. So that is kind of leading us down the path that you mentioned in your first question. It's very difficult to revoke a licence because the legislation doesn't allow us to do so. But one of the reasons that we can not allow a licence for a rented property is if the landlord is not a fit and proper person, or the licence holder who's been put forward is not deemed to be a fit and proper person. So that is the kind of knock on. I have to say, I've been an environmental health officer for 21 years, and I don't recall a landlord not actually doing the repairs that have been asked of him once we've gone down that route. They don't want the financial penalties, or the publicity around it. And so we haven't been in a position in the past where our enforcement notices haven't led to the actual positive outcome of having the works done.
Okay, thanks for that response. Councillor Hymans, Tammy, please.
Am I right in saying that, I mean, in the document under 5.19, it states that the total number of licence applications received under the additional HMO licensing scheme is 3,454. Is there any assessment of what proportion of properties that are being rented out as HMOs that is? Because that strikes me as relatively low, given that the percentage of private renters in Haringey, I don't know what the figure is exactly, but it's like 50%. And there's hundreds of thousands of houses. This seems like there's a lot of landlords without an HMO license, even though there are, as Matt says, 3 or more unrelated people in the property.
Yeah, so we've obviously had to go by the evidence that we've been able to establish from the data that we hold on the private rented sector, which is extremely limited. We don't really know where our private rented properties are in our borough. That we're no different from other local authorities in that sense. We did do a piece of work which overlaid tenure intelligence to identify where we thought rented property was, but it's very difficult to identify property which is rented as a house and multiple occupation. So this figure has come from that tenure intelligence, and the figure quoted was just under 5,000, and that is for shared type HMOs. We know that this is likely to be an underestimation. It's predicted modelling. And what we've then had to do from that predicted modelling is look at how many of those licences we expected to come in over the 5-year period of the scheme. So yes, there is likely to be a lot more and we know other local authorities have had, found more HMOs as part of the HMO licensing scheme, but we've based that on the evidence that we've been able to get through our intelligence.
Just to follow that up then, I know that for those landlords who don't have a licence, there are mechanisms through which tenants can get recourse. So there's the rent repayment order process, for example, and I have friends in Tower Hamlets who've actually been through that process, and I know that they had a specific project where over £200,000 was reclaimed directly into tenants' pockets from landlords who hadn't had the licence. With us expanding this scheme, is extra resources and capacity going to be given to that so that there's a specific project available for tenants to get that money back? Because I think it would make a huge difference to private renters, and to make a real stick to say to landlords, if you don't get this license, you could lose a lot of money.
Yeah, so we're currently working with Cambridge House, and they are specifically working with tenants, partly where there's been some sort of landlord harassment involved with the case, and also to facilitate tenants where we've identified unlicensed HMOs to obtain the rent repayment orders through the courts, and that's something that the tenant has to do themselves. But also we are linking in with Justice for Tenants, who are also a not-for-profit scheme who are specifically supporting private rented sector tenants to do exactly the same thing. And the benefit of working in partnership with those two, one Cambridge House charitable organisation and Justice for Tenants, is that it helps us with our prosecution or civil penalty cases, because they're able to gather the evidence that we also require from tenants in order to take our cases through the tribunal. So it's a good situation for us, because sometimes as authoritarians, tenants don't want to work with council officers. So getting witness statements and the evidence that we need can become quite difficult. But by working with these partner organisations, we're able to use the evidence that they've used for the rent repayment order to then take the case against the landlord for failing to licence that particular property as well. So we're benefiting from those particular schemes, and also just the training that it offers our officers as well, because it's an area that we're not familiar with. So we're benefiting from working closely with those legal advisors. You know, to try and make sure that our officers develop in that area as well.
Thanks. Could I just, going back to the table in paragraph 5.19, we've got a total number of compliance checks undertaken, 1,003. Now, presumably those are compliance checks undertaken on landlords who have applied for or potentially been issued a licence. Are we also proactively going out and doing checks on houses that we believe are being rented out as HMOs under that definition? I know this used to happen from my own experience, and how many of those are being done in terms of just going out and, you know, we think this is an HMO, doesn't have a license, let's just check.
Yeah, so we did a massive project during lockdown and then post-lockdown, which involved identifying property that we thought was HMOs that wasn't licensed, and then we followed that up with door knocking. So we're currently now at the stage where we're using those resources to do the compliance check. But we obviously do work on any intelligence that we may get regarding an unlicensed HMO, and that's exactly what we do. But we're now in a position where we're sort of taking immediate enforcement action if the landlord hasn't got a reasonable reason as to why they've not licensed that premises with us. But ultimately, the goal is that they will license, even if we continue to prosecute them for failing to license. Most landlords are applying for their license retrospectively, and they'll go through then the licensing process.
Okay, thanks. Councillor Blake has a question.
Thanks, Chair. Councillor Hymas actually asked the key question that I'd identified, but I was just going to make a suggestion, maybe for a future meeting, if we could invite one or two of the community sector partners that are listed. Yeah. Thanks.
Apologies, sorry, I just missed with the interference what you said.
No, it's just a suggestion if we could invite to a future meeting one or two of the community sector partners that are mentioned at 5.10.
Yes, certainly. We could certainly do that. Okay, Councillor Hymas.
Just to add to Mark's point, we have some strong renters unions and community unions in the area as well, who I think could be useful partners as well, particularly given that we signed a number of pledges from the London Renters Union in the lead up to the local elections.
I was going to suggest, seeing that this is something that affects a large number of our residents. I think it's over a third now of households in the borough rent privately. Most don't have much option other than to do that, and it's not really something that this panel has looked into for a while. That maybe we set up a scrutiny review into what the council's doing, have a look at best practice, hear from expert opinion, hear from other authorities that maybe have got more developed schemes. I believe, for instance, Newham, I think, has a selective licensing scheme across the whole borough, which they were able to do because they set it up so early before the government was so restrictive. I think that's my understanding. Anyway, I don't know what other panel members feel about that. Okay, well, I think in that case, maybe I actually, sorry, I did have one more question, but I'm going to suggest that we following my question, we draw the item to a close and follow up. Go on, Councillor Hymas. Sure. Go ahead. I've got one more question as well, but yeah, go ahead.
I had read in the so there was a evidence report for consultation 2021, and one of the things that I noticed was that one point about the scheme, the selective property licensing, said promotion of joint working with other agencies, which included border control / immigration. Now, I assume that was probably part of the normal recommended kind of set of features that comes with an application to the Secretary of State. But was that included within our application?
Sorry, I had a problem unmuting myself. Yeah, no, it's not something that we've included in our application to the Secretary of State, and was something that we put quite strongly in our equalities impact assessment around the reasons why we would prefer not to work with those particular agencies. And partly because we've taken a long time to build up trust with our private rented sector residents, and they have a very different functionality to what we do, and we wouldn't want to break down that relationship and sort of trust that we've spent a lot of years building up. So we wouldn't be advocating working with them on a voluntary basis. The only time that we would envisage ourselves working with them is if there was a legal requirement for us to do so, which is very limited circumstances from what I understand, reading into where those type of joint agency visits may have to be undertaken. So yeah, no, that wasn't part of our submission to the Secretary of State.
Okay, thanks. Go on, Mark. Go ahead.
Sorry, Chair. No, it's just a point on my understanding is that the council has no powers in terms of affordability in this whole area in terms of what rents are set, if that's correct. But I presume we could collect data, and I think that data would be quite useful actually in terms of what people are actually paying, to get an idea in terms of what the averages are around the borough and to make that publicly available. So I don't know if officers can give us any kind of feedback on that, if that's part of their plans. Thanks.
Yeah, that wouldn't be part of what we would be doing as part of this particular scheme. I think the GLA, do collect some information regarding market rents, but we wouldn't be collecting that as part of the licensing scheme.
Councillor Carlin wants to come in on this one.
As Lynn says, the DLA does collect that information. It's one of the ways that they decide on local housing allowance for housing benefit, etc. So that information is available. It can be quite it's not a micro level, but we would know how much the rents are across the borough. That information would be collected.
I mean, my point is obviously if you are a private rented tenant, it'd be quite useful to know whether what those market averages are and if you're paying above them, because obviously you then have the right then to move or obviously to use that in terms of negotiations with your landlord. Obviously, I know we don't have any powers, but yeah, I think the more information we can make available in this space, obviously, the better it is, particularly this cost of living situation that we've got at the moment.
On Councillor Hymas.
Just to add to that, I mean, it would be a really good opportunity to also think about the differences between the East and the West in terms of rent increases after the licensing scheme is implemented. Because if we find that in the East, having the licensing scheme causes rents to go up a lot, that would have to then, I think, rethink our plans, because fundamentally affordability is the main issue here for most private renters in my experience.
Okay, that's a comment, I think. Thank you very much. Okay, great. Right, I just had one concern from page 15 of the pack, which is the objectives for the selective licensing. where in the first and the third line in the third column, it talks about the lifetime of the scheme and the end of the scheme. So is this selective licensing scheme time limited in some way? Or if not, why does it talk about the end of the scheme?
Yeah, unfortunately, both discretionary property licensing schemes are time limited. They can only last a maximum of 5 years, and then you have the opportunity to seek further evidence to see whether you have what it requires to ask for the scheme to be renewed. So on both schemes, the additional HMO licensing scheme, that would be something that we would have to consider whether we've got enough evidence to come back to Cabinet and say that we would need we need a renewed scheme. And with the selective licensing scheme, it's exactly the same. So we would have to go back to the Secretary of State and ask them for permission to have a scheme renewal, the same as Newham did, and Waltham Forest have also just had permission to renew their selective licensing schemes. So yeah, additional HMO licensing, the decision making was delegated to local authorities, but with the selective licensing schemes, if your scheme is larger than 20% of your overall private sector stock or the geographical area that you want to designate, then you have to go to Secretary of State for permission for those larger schemes.
Okay, that sounds very much like if the scheme works, then we don't get to continue it, and if it doesn't work, then we get to continue it.
I think going back to what Councillor, it could be going back to what Councillor Haynes said, in that if we've identified in that 5-year period that we feel that there's more HMOs that haven't been licensed in that 5 years than we expected to, or that there's still a need for us to have a scheme to ensure compliance, then as long as we've got the evidence to suggest that, and we can show that by working in partnership we've got things that licensing will still allow us to achieve, then we would we can go for it. So I think that is definitely something that that we will be considering as a private sector housing team.
Okay, thank you very much. So thanks for that. And so I guess the next step is for us to get together as panel members and thrash out terms of reference for a review into this. I definitely hear panel members' concerns that what we're doing as a council benefits the people who are living in the private rented accommodation, which is a large proportion of the borough and ever increasing. And I know from my own experience that it doesn't always do that. I know that it's not very easy for us to, our powers are very limited, but I think it would be quite good for us to have a look into what other boroughs have done, what experts in the field can say to us about this, and maybe we can work together with the executive to maybe help find a way of making sure that what we're doing in terms of regulating the private sector works in the best interests of our residents. Great. Okay. Right. We'll take this elsewhere then. Great. So next item on the agenda is the empty homes policy update. Lynn, this is you again. So please, if you could take that away, that'd be great. Thanks.
Yep, so this is a quick update just on the revised empty homes policy, which we did in 2020, took to Cabinet in 2020. It's allowed us to update the previous policy, which was quite out of date in terms of grant funding that was available for homeowners, for example, and also our methodology and just the way that our organisation is structured now. So the revised policy had key parts in it that were the same, but also had items removed that were in the previous policy, which ran, I think, from 2010. So it was very out of date. It's also given us an opportunity to re-look at and re-engage with our empty homes in the borough. We get the information regarding empty homes from council tax. They produce a list. The legal definition of a long-term empty home, albeit which is outdated as well, is anything that's been empty for more than 6 months. So we have, over the last 2 years, gone through most of the empty homes that are on the council tax list, and we kind of banded those from long-term empty homes, which for us was homes that had been empty for longer than 10 years. Then we looked at homes that have been empty for more than 5 years. Then we did quite a quick exercise to look at homes that were empty for less than 5 years, which is the main number within our kind of empty homes stock. And we agreed that we would target our resources on all homes that had been empty for 5 years or more. I've got an officer in my team who has been working on that, making contact and trying to find who the empty homeowners are and to establish the reason why those properties have been left empty. And so there's information, you know, in the paper around that. So again, I'm quite happy to open it out to questions in order to maybe provide some extra clarity. Just 2 things: we approach empty homes in that we offer advice, guidance and support to empty homeowners in order to bring that property back into use as a starting point. And then if we feel that there's been no progress or there's unlikely to be progress, then we have a series of enforcement letters, which is part of the process, which then would allow us to compulsory purchase that particular property should we get to that point. So it's a best practice legal process. Those letters can be stopped at any point if somebody then starts to bring a property back into use and there's contractors on site, and then equally we can start them again if we feel the progress is not being made to return that property back into use. And there also is a large section of empty homes which are exempt from enforcement action due to the reasons why they're currently being left empty. So it may be that somebody's in residential care or in hospital or in prison, or where the property is going through probate. We've got no right to then pursue those properties under those circumstances. So that all ties in with the sort of investigative work that the officer does in order to establish why the property has been left empty.
Thank you very much. Okay, Councillor Moy, so you first again. You're very quick off the mark this evening. No, go ahead.
Yeah, thank you for that report. I just wanted to ask. So, in your definition, you've got the those that are long term, and you've got what's the other term that you're using?
Transactional.
That are not classed as empty.
Yeah.
Sort of in between or short term empty, and within that you've got properties that are fully furnished and may be used as a second home. I mean, Haringey doesn't strike as the kind of place where people would typically have a second home, but do you have any idea of numbers of properties that we are talking about that might be used as a second home?
I don't have those numbers. I do believe that it was something that was recorded by council tax, but is no longer required to be recorded by council tax. So those figures are not available, but we wouldn't include them in our investigative list because they're exempt by virtue of the fact that they're a second home.
Okay, so I have a second question. That is, so the table that you have where you've looked at properties which have been empty for 5 or more years, 88 properties. Do we have any kind of comparative data in terms of how we sit when compared to other neighbouring boroughs? Because if you've got only 88 properties, that have been empty for over 5 years, I want to understand whether that's a high figure or a low figure. Is there anything that we can compare that against?
There is data released in terms of empty homes, but it's very much based on council tax information. So it obviously fluctuates continuously. but there are details published of other local authorities' emptied homes. I don't have those to hand in terms of how long those properties have been left empty for.
So, Chair, can we have an action so that maybe we look at other neighbouring boroughs? Because at this moment, just being given the stats for Haringey, I don't know whether this is, this is a high figure or low, how we are doing. If we could have some comparative data for other, neighbouring boroughs that are similar to ours, just so that we can get an understanding of how we're doing in terms of, 88 properties, is that fairly standard or not?
I think that would be useful, but I'd also be interested in really understanding what it means to say that a home is substantially furnished. Sorry, apologies for that. It says here in 5.5 that substantially furnished empty homes cannot be treated for council tax purposes as an empty home either. So does that mean that they are then, excuse me, that they are by law exempt from our empty homes policy? Or is it just that because we're reliant on council tax data that we just don't have the information that we need in order to enforce against these policies these homes should we wish to? Because what concerns me is that somebody could kind of gain an advantage by just putting a couple of pieces of very, very cheap furniture in their otherwise empty home. So a little more clarity on that would be helpful, I think.
Yeah, so it is mainly down to council tax. I think what we've got to appreciate is that the empty homes that we would be looking at to bring back into use are going to be those ones which we have the powers to do something about. And so it has to be in the public interest test for us to be able to take enforcement action against an empty home owner. So it would be unlikely if somebody could prove that that property was semi-furnished and was used by somebody who commuted to London for work on a 2-day basis, etc. For it to be in the public interest for us to pursue those types of properties, and we probably don't have the resources to do that. So we do tend to focus our attention on those that have been left empty for the longest, and those which are causing a nuisance to the local community in some way, and they tend to be the ones that we have more of a realistic opportunity of either enforcing the sale of that property or taking the compulsory purchase order for that particular property. So it has to meet the legal test essentially in order for us to pursue those particular enforcement powers.
Okay, thanks. Go on, Councillor Moyd.
Yeah, sorry, I have one more question. So with new developments, you have these kind of expensive flats that are going up in different places. We often hear rumours that it's overseas buyers who are just buying them up, and in some cases these are not rumours. For example, in another borough in Southwark on the Haygate estate, there's an entire development where every single flat has been bought by an overseas buyer. In my ward in Knoll Park on Clarendon Road, there is a development there on the former gasworks site, and some of the flats are very expensive indeed. They could be as much as £800,000, and I know for a fact that they were being marketed to Chinese buyers. Some of the initial brochures were in Mandarin. Is there any truth in any of that in Haringey, in some of the developments that we have? Maybe overseas buyers are buying them and they're lying empty, and if so, the figures that you've presented, do they include those kind of properties that have been bought by overseas buyers?
So there may be some of those properties in the general statistics, depending on where they sit in terms of how long they've been left empty for. But again, we would have to go back to the fact that we would have to question the reason why we were taking enforcement action against those particular owners of those empty homes. and the reason for us wanting to have those brought back into use. I mean, empty homes have to pay a council tax premium, so it brings in a lot of revenue for the council through council tax charges. So again, you have to weigh up the need of the borough and the likelihood of that property providing, you know, a home for somebody rather than it sitting empty, as well as, you know, the reason why we would be wanting to pursue those particular homeowners. I think it's probably a wider policy decision for the government to make around, you know, people who own second homes and people who are leaving those second homes empty, in terms of, you know, whether those particular properties would provide accommodation for somebody else who wanted to reside in Haringey. But the main purpose of our enforcement action through the revised empty homes policy is to target those particular properties that are blighting the neighbourhood or causing nuisance, attracting antisocial behaviour, and just bringing, you know, the general appearance of the neighbourhood down, impacting on local residents. When actually, you know, if we can compulsory purchase those, they meet the criteria and we can bring those ones back into use. That's really where we are focusing our attentions, or ones where we know there's very limited likelihood of them being brought back into use because the owner has either died and there's been nobody to pick up the estate, or the owner has absconded in some way, which makes it a lot easier for us to then have the evidence that we can compulsory purchase the property and sell it on to a developer, for example.
Councillor Parlin.
If I could just reiterate what Lynn has said, it's important to recognise that this policy that was passed in July 2020, our revised policy, it is really that we only actually enforce against properties that are causing a blight to a neighbourhood. So if it's not again, so the policy is not for us to actually try to buy or either forced sale or CPO properties that are lying empty, that are not causing any trouble to their neighbours. That's not at the moment what we're doing. The policy is quite clear. As Lynn has explained, it is because we have to use the public interest test as to whether it's in the public interest for us to actually proceed to issue the notices, etc., and then to either go to forced sale or CPO to buy the property. Now, that is something that we may wish to reconsider and look at around that. In the report that went to Cabinet in 2020, it was noted that there has been a substantial increase in properties in Haringey that were empty, about 20%, 15 to 20% from what I could see from the papers. So I think we need to proceed on the properties at the moment where we have issued the notices, and then proceed to as this report says, to bring them to a decision making, presumably Cabinet, to decide on proceeding with either a sale or CPO on the ones that we can do, and then roll it out as we go forward. Obviously, as I'm sure you know, I think I'm correct, Lynn, in saying that if we were to proceed and then the owner was to fix up the property, etc., bring it back into use, then we couldn't proceed really in any event. But certainly, hopefully, the action that we take in taking that step to say that we will proceed will encourage the owners to do something about the property. We do have some properties that are causing quite considerable problems in the borough. Thank you.
Yeah, so if I just could answer that point, Chair. Oh, sorry.
Sure, no, go ahead.
No, I was just going to say that obviously the enforcement letters are normally a very good remedy, in that, you know, most people see those as a proper threat in terms of the enforcement action, and they will start to take measures to bring those properties back into use. And they tend to be people who have inherited property, who really just don't know what to do with it, or there's still an emotional connection to the property, and they've allowed that for whatever reason to continue to stay empty. We did a huge piece of work where we wrote to nearly all the empty homeowners that were 5 years or more and reminded them of the increase in the council tax charges, 300% for properties that have been left empty for more than 10 years. And a lot of people responded to those letters saying, actually, the property isn't empty. It's just that we haven't informed council tax of the occupation. We've asked them to do that. And, you know, and a lot of the empty homeowners have. Just in terms of the end of the 5-letter process, is that if we do go to Cabinet for decision for CPO, at that point, we normally find that a lot of owners will then come forward to the council with their plans to return that property back into use. Albeit that we have got a couple at the moment that have already suggested that they will go through the Secretary of State appeal process if we decide to compulsory purchase the property. But usually at that point of going to Cabinet and that seal of approval from Cabinet that we can pursue these ones, most homeowners do then start to take steps to return the property back into use, or will put the property on the market, because it is a costly process for both sides. The compulsory purchase process.
Thanks. I'm going to bring in Councillor Blake in a second, but I just wanted to check in those cases where we do take the enforcement route, it seems that there's 2 options open to us, either in enforced sale or CPO. What is it that decides which of those routes we take? Is it a matter of what we're allowed to do by law? Is it a matter of what's in the policy? Is it a matter of operational decision?
Yeah, all of them. We have a panel. So we're meeting on the 4th next Monday, and it's made up of legal, council tax, other council services who may have had an input with that particular property during its course, with maybe, you know, enforcement notices or planning notices, etc. And we make a decision mainly based on our legal experts' opinion, to be fair, on what would be the best next steps. It's legal who have to take the order to the Secretary of State, so they have the final decision really, in terms of whether they think there's enough evidence and public interest and council interest in us taking compulsory purchase orders. The enforced sale route is a lot easier. It's something that's led by council tax, and there has to be over £1,000 worth of debt on the property. That can either be council tax debt, or it could be debt where we've served an enforcement notice, for example, boarding up, or if we've had to get the garden cleared in default of the owner, that charge then goes on the property. So over the years they can rack up considerable debt if we've done that particular work in default of the owner, and sometimes the enforced sale is the better option for the council rather than incurring the lengthy process that can be involved in compulsory purchasing a property. So we weigh up all the pros and cons essentially, and do sort of a best value analysis as well, in terms of the likelihood of a successful outcome. If we have an unsuccessful outcome, we can't claim any of our costs back from the capital funding that we have set aside for compulsory purchase orders. So, you know, that's a cost to our legal services and to the other council services that have been involved that we can't recoup back from the capital funding process. So yeah, it's a panel decision.
Okay, thanks. And that capital funding, is that part of the HRA, or is that part of the wider capital budget? And yeah. What do we do once we've compulsorily purchased a home? Do we then bring it into use as a council home?
No, it normally gets sold. So there is a process that legal follow, which I believe involves sealed bids. So the property is valued on the day that the possession order is granted, and then there's sealed bids. And then obviously the winner of the sealed bid will purchase that particular property. And then there is a whole legal costing process in terms of what the owner receives out of that purchase money, compensation money, which I believe is 7% of the value of the property. And then, so yes, and it tends to be a developer then that will redevelop that property and bring it back into use.
But given the need we have in the borough for council housing, is it just not legally possible for us to do that, or not financially possible for us to do that, or which of those?
Yeah, I think it's not legally impossible. I think the acquisitions team have a criteria that they currently have for the types of property that they wish to purchase, and the majority of the properties that we have that we've gone through the compulsory purchase process is, I think, generally out of their remit in terms of the amount of money that it would cost them to redevelop the property, purchase it and then redevelop it. But the acquisitions team kind of hold that that purse string, unfortunately. But we do meet with them regularly. We go through the list, and if there's anything that obviously sticks out to them, that would be one that we would obviously make as a priority. But there hasn't been anything on the recent list.
Thanks, Lynn. Councillor Carlin wants to come in on this.
This is something that I will be looking into. I am aware of our need to acquire properties. We already acquire properties to let out as temporary accommodation through our wholly owned company. So this is an area that I'm looking into.
Thanks. Okay. I look forward to hearing more about that in the future then. Councillor Blake, you had a question.
Thanks, Joe. No, it was just a follow-up really for Councillor Carlin, following Councillor Mohit's point about empty properties and foreign ownership. It seems to me a political point. I probably kind of look at the situation. It may not be something the council can take any action on unilaterally, but I would really appreciate if this item could be taken to London councils, because I actually work 2 days a week in the King's Cross regeneration zone, which I certainly know in some of the local communities bordering that scheme causes a great deal of resentment. In terms of this practice. I know where I grew up in Wembley. It's always been commented to me by local people there, many of whom can't afford these flats. It's it's again a real source of resentment. So I think politically there is an issue, and I think it's a big issue for Labour councils. I don't know where Southwark are with the issues that were raised around the Haygate, but I think politically for Labour councils, it's a big issue and at least deserves some kind of discussion at that London Council's level. Thank you, Chair.
Yes, Councillor Cunningham.
I agree that it is a huge issue, and it's something that Haringey has not historically had the same level of properties being bought and left empty as more central locations have. However, given the amount of building that we're doing and the changed demographic, so for example, Clarendon, etc., we certainly may start finding that becomes more of an issue. At the moment, it seems to be that a lot of the new builds are bought privately and then rented out, or used for Airbnbs or whatever, but not left empty. Now, I know that Islington looked into it at some length to try to prevent this happening. And what they did was try to insist on a covenant on the building, which said that whoever owned the buildings would, through the planning process, that whoever owned the buildings wouldn't be able to leave those flats empty. At the time, there wasn't the possibility to levy additional council tax premium on empty properties, but it is the people who are buying these properties as investment vehicles can afford to be paying the council tax on them because they're paying an extortionate amount of money. I agree that it is certainly something that needs to be looked into, but it is very difficult because the law, as I said, the way that Islington got around it or tried to deal with it was to was to put these covenants on the buildings so that the properties couldn't be left empty. But I agree with you. I certainly think it's something we're going to have to keep an eye on in Haringey.
Thanks, Chair. I'm glad to hear the cabinet member's response. I mean, the only thing that I'd add to that, I think I've mentioned Labour councils. There is a big issue, I think, in terms of where the balance around housing policy is. Other parties can deal with themselves, but particularly I think for the Labour Party, it needs to be weighted against investment. Thank you.
Okay, thank you very much. I can't see any further questions. So thank you, Lynn. Thanks for answering the panel's questions on those two items. Thank you very much. And obviously, if you want to hear about the local plan, then you're free to stay. But otherwise, you're free to leave the meeting. Thank you very much.
Thank you. Thanks, everybody.
Okay, and okay, thanks. Bye bye. And Rob and Bryce, thank you very much for waiting patiently while we dealt with those items. Next item is an update on the local plan. Bryce, you'll be taking this one, will you? Yes, please go ahead.
Thank you, Councillor. So we've provided an update on the new local plan, focusing on engagement and consultation, which we've done to date, evidence base in support of the emerging plan, and also detailing the next steps and direction of travel in terms of that plan. So there's quite a lot of detail in the report itself, so I'll just pick out a couple of key things. First of all, well, why is the new local plan important? Well, it's a key corporate document which will engage communities to set out a long-term vision for development and change in the borough. There's a number of reasons for the update of the plans. We've got an existing local plan dated in 2017, but they include to reflect the council's latest strategic aspirations and ambitions and to respond to the climate emergency which the council declared in 2019. So the most substantive engagement we did was the first steps engagement, and there's quite a lot of detail in the report on that, but that was the opportunity for residents, businesses and other stakeholders to feed into the new local plan process from the beginning of the process. So that was about starting a conversation and thinking about the kind of issues and challenges and some of the options and opportunities to address those. So we've got an indication in here of the response to that. So I've got 1,500 down here, unique responses. I think the final totalizer is going to be closer to 2,500. So I think that was an impressive effort. And then I've just detailed some of the key consultation messages which we received. Now, there was quite a lot of variety, but there were some key themes. Good design was one. The need to do more to address the climate emergency was another. A focus on delivering not just affordable housing, but genuinely affordable housing. A focus on not just delivering more new homes, but new homes which are of the right quality and the right type to meet local needs. There was a big emphasis on green spaces and well-being, which you might have expected given we consulted through the pandemic. It was really stressed that open space is key to our residents, and that particularly came through strongly from younger people, from which we got a big response from, as a cohort. People also told us that it was really important that we protect and enhance the borough's rich cultural diversity. We got told quite strongly we should protect employment land, we should be more restrictive than we currently are. And also, despite the efforts to engage more people, there is an expectation that we'll continue to do more to engage people, particularly giving support to community groups and doing more to reach these seldom heard groups. So the second key part of the update is around evidence base. So this is evidence base to inform and support the new plan. So we've got a list here of key pieces of evidence which have been completed to date around housing, archaeology, Egyptian traveller needs, employment needs, retail needs, and some work around sinks, so sites of importance of nature conservation, some stuff around flood risk. And a couple of bits of work outstanding. One is a whole plan viability study that we're working on at the moment. And another key piece of evidence which we're working on and delivering in-house is a character study. And this is looking at opportunities for change and growth in different parts of the borough. Also got a bit of detail in here on what we're doing in terms of member engagement. So we have set up a new local plan member working group. So that's chaired by the cabinet member with responsibility for planning and that comprises members of Strategic Planning Committee, which is also the same as the Planning Subcommittee. So they fed into the process so far on 2 occasions, and that member working group is going to be reconvened in the near future to inform the draft local plan. So in terms of next steps, the key thing to highlight is that we are looking to get approval to consult on a draft local plan. So we're aiming to get approval in the autumn to start consultation on that before the end of the year. So that will be quite a significant milestone. At the same time, we'll publish all of the evidence base which we've prepared so far in support of the draft local plan. And we'll also publish a detailed consultation report setting out what people told us during the first steps engagement and through other engagement, and what we've done about it. And just to give you a flavour of the new local plan and the direction we're headed in, I think the 3 key themes it's being shaped around are sustainability, health and wellbeing, and reducing inequalities. And we're very much thinking about housing and employment as tools to achieve those 3 aims rather than ends in themselves. I've just got a few bullet points here about policy directions. So enhanced focus on sustainability, much stronger policies in relation to delivering carbon reductions, clearer approach to enhancing biodiversity, including through biodiversity net gain, which becomes a legal requirement from next year. We're also looking at a dedicated trees policy. Trees don't appear too strongly in the current plan, so we want to reflect the importance of those. Greater focus on the delivery of genuinely affordable housing. So this is building on the draft housing strategy, which was approved by the council for consultation, is going out for consultation later this year. Greater protection for certain types of employment land, having regard to the fact that we've lost a lot over the past, and we've got rising land values for a range of office uses, particularly industrial uses and warehouses, and a continued focus on high quality design, which is already a key focus of our existing plan, but with a particular focus on not just buildings themselves, but also the spaces between buildings. So that is the report in a nutshell. Thank you.
Great. Thank you very much for that, Bryce. So I'll start off on this one. I basically got 2 questions. One around the kind of the direction of travel stuff, and one around the risks. So around the direction of travel, we've got a few bullet points there that basically say what the policies in the local plan are going to be focusing on. We've got sustainability, we've got enhancing biodiversity, we've got genuinely affordable housing, protection of certain types of employment land, securing the highest quality of design, all this coming from both the evidence base and the early stage consultation about what people want. So this is all really, really good. But what I'd like to know, and maybe this is a question more for the cabinet member than the officers, is when we're going to start seeing some more of the detail of exactly what these policies are going to look like. Yes, it's great to say that we're going to be providing that genuinely affordable housing that our residents need, but when are we going to get our first look at what the policies in the local plan are going to look like about that? Do we need to wait now for the publication of the cabinet papers in the autumn, hopefully? So that's my first question. The second question really is around the risks generally. I mean, obviously it takes a long time to put together a local plan, and I know Bryce particularly and Rob have been working really, really hard on this for quite a long time now. This local plan is being put together really in large part to respond to changes in policy, both in this borough and in London. But it's taking, I mean, these changes in policy here date from around about 2018. In London, more widely, they really date back to the election of Sadiq Khan as Mayor of London in 2016. We're looking at adoption of the local plan, new local plan in 2024. In the meantime, the government, which isn't necessarily completely in line with that local policy and London policy, is bringing in all kinds of ever-changing guidance, regulations, all of this stuff. How can we be confident that, given the amount of time it takes to put together a local plan, unavoidably, how can we be sure that it's still going to be absolutely fit for purpose when we adopt it in 2024, which is basically 2024. That's when we're looking at a new mayor of London potentially, and a new council maybe. We don't know. So I don't know who'd like to respond on that. I can leave. Yeah.
I mean, having looked at some of the evidence and some, or we're already going to need to update some of the things that we've had in have in some of the documents. So I presume that, you know, before everything goes out to consultation, everything will be updated and relevant, which means that it's not, we're not looking at it at changes going back 6 years or whatever it is, but we'll only really be looking at changes going back a couple. But I'll leave officers to ask how we deal with those last couple of years. I presume we may be, I don't know if we use supplementary, I'm not sure what we do.
Thank you, Councillor. So in terms of the route forward, I think in the first instance, we would be looking to share more detail with the new local plan member working group, which has been specifically constituted for that purpose. Following up, the next step would be to go to Strategic Planning Committee in advance of Cabinet. So Cabinet wouldn't be the first time that information was seen publicly. I mean, we would be happy to bring further information back to this panel if there are specific policies which you'd like more detail on in relation to existing evidence and direction travel. We would be happy to do that. It is a big document with a lot of detail, so I think you need to be quite clear about what you'd like information on, but happy to provide that. And in terms of the second question about it being a process, it is unfortunately a process. It's taking a bit of time. A couple of things I would mention in that regard. So we are looking to really push the boundaries in a couple of areas, and that is taking some time. So we are making sure that our evidence base around things like sustainability is completely watertight. So when we do come forward with this draft plan, we expect it to go beyond the existing London plan. So we are thinking ahead to future changes. So we know what's likely to happen in the future, and we're trying to get there early. In addition, aware that there are changes on the way proposed by the government through the Levelling Up and Regeneration Bill. I think some of those changes have been on the way for quite a while. What we're looking to do is future-proof ourselves in the context of those changes. And another reason why the plan has taken a bit longer than we anticipated is because we are trying to future-proof ourselves. So we've put a lot of resource to mapping the plan, so it's digitised, data-based, which will reflect what the government wants to see in a couple of years' time. So I think we are ahead of the curve in terms of a lot of the changes we're going to need to deliver in the future. So those will be a couple of observations I add in that regard.
Great, thank you very much, Bryce. Councillor Blake.
Thanks, Chair. I had a few points that were more sort of employment related. Some of them might be related to the plan, maybe some of them aren't. I just wanted to know how much input the Economic Development Regeneration team have had in all of this. I wanted to know around gaps in the employment market post-Brexit and what we're doing about them, and linked to that sort of training opportunities and sort of skilling sort of local workforce, and particularly younger people up for that. And last point really is around supporting key workers and how we can do that more, because I think you know, and I think it also goes up in terms of where the gaps are in the employment market. But I think if we can support key workers, particularly around affordable housing, you're more likely to keep them in the profession and keep them in those local services that we desperately need to, you know, keep going. Thanks.
Thank you, Councillor. So in answer to your first question, how closely we're working with Regeneration Economic Development colleagues, very closely. So we commissioned the evidence base with them. That's been prepared alongside them. So they've input to that. We're also working closely with them on some new evidence around workspace. So looking at stuff in quite a fine grain, looking specifically at the needs of our residents and our businesses. You mentioned around employment and skills, so working very closely with the employment and skills team around a more robust policy in terms of what we secure through Section 106. So that's going to be a major focus of the plan. And in terms of key workers, so we've commissioned a bit of evidence around the type of housing which is needed in the borough. That's actually already published alongside the draft housing strategy, but that looks at needs like key workers and what the council can do to meet their housing requirements. That will also be a key focus. So all these things have been taken into consideration, and hopefully when this is available publicly, you'll be able to see more robust policies around some of these key areas like workspace, like employment and skills, and affordable housing, which is genuinely affordable to the borough's residents.
Great, thanks, Bryce. Councillor Hymas.
What's the difference between genuinely affordable and affordable housing?
Very good question. I mean, I guess it comes down to semantics, but I think it is the case that a lot of housing, which is technically affordable housing, is not affordable to London's residents. So we're talking about some of these intermediate tenures like shared ownership. Now, shared ownership is affordable to some people, but for the majority of Haringey residents who are in need of affordable housing, it's not affordable. So when we're talking about genuinely affordable, it's housing which is affordable to the majority of people who can't access housing through the kind of market, basically. So it may end up being the case that we budget something differently in the plan, but that's what we're getting at in that context.
So I guess, I mean, a kind of related question is about this housing target, which obviously seems quite difficult to meet if it's 1,500. Does the local plan have to take into account how, in order to achieve that goal, there may be, you know, you may find yourself in a situation where you can't deliver the percentage of genuinely affordable housing that we want under current market conditions? And how are you going to respond to that to ensure that, you know, the percentage that we put in the local plan is as high as possible?
Yeah, good question. So 1592 is the housing target which the council is set in the London plan. So we're required to reflect that in our own local plan. So that will be the housing target. So 16,000 over 10 years. A key piece of work we've commissioned and is completed and is published on the council's website is a strategic housing market assessment. So that's looking at, of those 16,000 properties, what type of properties do we need to meet local need? That indicates that the need for affordable housing is exceptionally high. So this local plan will be aiming to deliver as many affordable homes as it can viably deliver. And a key piece of work which is still outstanding and is underway at the moment, but it's listed in the report, is a whole plan viability study. So this is looking at what developments in the borough can viably deliver in terms of affordable housing, in terms of affordable workspace, and in terms of high quality sustainable buildings. So we need to look very carefully at the implications of our policies in terms of viability, and we need to establish what the correct balance is for the local plan. But we will be seeking to push the boundaries as far as we can in terms of affordable housing and ensuring that it's the right type of affordable housing. So there'll be a focus on social rent.
The final follow-up. So can you say to developers who are trying to build, could you say to them that in this case shared ownership would not be part of the affordable housing percentage which they're asked to deliver?
So the London plan requires us to deliver an element of intermediate affordable housing as part of the overall affordable mix. So it's 30%. So we will be required to deliver some intermediate. We will need to make a decision as to what intermediate tenures are most needed in the borough. Our evidence indicates that shared ownership is not the most appropriate intermediate tenure in the borough. Although important to note, the government is pushing for councils to deliver first homes as intermediate affordable homes, which are discount market sale homes, and there's probably not a lot of need for those in the borough. So we will be providing policy setting out what intermediate tenures we want in the borough. Essentially, we just need to decide what the right mix is.
Just a final comment is that, yeah, it's not there's 10,000 people on the temporary housing waiting list. To tell them, oh, you can have an intermediate rent home is just a kick in the teeth, I think. But that's where we need housing, right? So it's just.
Just one follow-up point. So I would agree with you there. The evidence indicates that the majority need is for social rent. But interestingly, one of the messages that came through the first steps engagement is that we need all types of affordable housing. So whilst people did say, yeah, we need social rent, and that's generally accepted, there are also a large number of people who would benefit from these intermediate tenures. So it's really figuring out what the best mix is for the borough.
Okay, thanks for that. Any more questions on this item? No, all right. Thank you very much for that, Bryce. Okay, next up is community infrastructure levy. So update on where we are with that. Bryce, are you taking this one forward as well? Yep, thanks.
Thank you, Chair. So this is a briefing note on the community infrastructure levy, so SIL for short, as relates to Haringey. So this details what SIL is, what strategic SIL and neighbourhood SIL are, details the council's adopted Haringey SIL and policy related to that, and it also sets out how money that we've raised from SIL is being used to support infrastructure delivery in the borough. So I'll just quickly capture a couple of the key highlights. So for those of you who aren't familiar, SIL is a levy introduced under the Planning Act in 2008. This is a levy that local authorities can choose to charge, so it is optional, and it's a charge on new developments, and it's for the purpose of raising funds for infrastructure required to support area-wide development, so infrastructure to support growth and development in an area. And SIL is set through the adoption of a charging schedule, and SIL itself is a charge based on the floor space of new buildings. So SIL has to be spent as follows. So up to 5% can be spent on administering SIL. So there are costs related to administering SIL, the collection and spending of that. 15% or up to 15% should be spent on neighbourhood SIL projects, and I'll come on to these in a moment, but these are projects identified in consultation with local neighbourhoods, and that's the key thing here. And that 15% figure increases to 25% where there is an adopted neighbourhood plan, and we've only got one in the borough at the moment, which is the Highgate neighbourhood plan. But the more substantive portion of SIL, which is 70 to 80%, may be spent on strategic SIL projects, and I'll come back to that in a second. So SIL is optional, but the council does have a SIL charging schedule that was approved in 2014. So it's been in effect for over 7 years, and it's raised quite a significant amount of money so far. The existing rates, the current rates, are set out in the council's annual SIL rate summary for 2022, which is available on our website. So we approved SIL in 2014 initially. We have undertaken a SIL review over the last few years, looking at whether there's scope to increase SIL rates in the borough. That SIL rate review concluded a short while ago, and the outcome of it was a revised SIL charging schedule, which takes effect from the 1st of September this year. And that includes increases in SIL rates in the east of the borough and the east of the borough only, because the evidence indicated there wasn't scope to increase them in the west of the borough and the centre of the borough. And as you'll be aware from the table, the rates in the centre of the borough and the west of the borough are substantially higher than the east of the borough, and this is based on viability evidence. So I've talked about strategic SIL, so this is the substantive portion of SIL. This is required to be spent funding infrastructure, so this is provision of, improvement of, replacement of, operation of and maintenance of infrastructure to support development of an area. So some things this could be spent on include road and transport facilities, schools and educational facilities, and sport and recreational facilities. They're detailed in the report. Important to note, so the council has adopted governance around how it will spend SIL, and that adopted governance says that strategic SIL will be spent on SIL eligible projects within the council's capital programme. So the starting point for accessing SIL is that the project must be on the capital programme. I think important to note that whilst it is a substantial amount we've collected in terms of SIL, there are a lot of competing demands for it, and because of that, the council set out some prioritisation criteria, and they're set out in the adopted SIL governance too. And in terms of the allocation of SIL, back in December 2020, Cabinet approved allocation of £14.5 million of strategic SIL monies to be spent on a variety of projects. So that wiped out most of the strategic SIL pot at that time. And in the appendix to this report, is some detail of those projects and an update on those in terms of delivery and spend of strategic SIL. Coming on to neighbourhood SIL now. So this is a bit different to strategic SIL. So this is the 15 to 25%, which is required to be spent on anything else concerned with addressing the demands that development place on an area. So this is a slightly looser definition of infrastructure than strategic SIL. The council's process of spending neighbourhood SIL is set out in our SIL governance document. It splits the borough up into a number of areas for the purposes of spending NSIL. Now, we identified an issue a number of years ago with the fairness and equality around neighbourhood SIL, and the council agreed an updated governance position, which was considered to be a fairer approach to spending NSIL. And that allows NSIL to be spent in a different area from which it's raised. So details of that are set out in the report. In terms of the allocation and spend of NSIL, so in early 2020, the council agreed to spend the NSIL pot, which accrued at that point, which amounted to about £2.2 million. And the projects which that has been allocated to are also set out in the appendix together with relevant updates. And then just lastly, looking forward in terms of future spending allocations. So the council publishes what's known as an infrastructure funding statement, and that covers infrastructure over a financial year. So we will shortly be looking at the financial year which ended on 31st of March this year, and we'll be publishing an infrastructure funding statement. That will set out the current position in terms of SIL we've collected and which is available to spend. And once we've got that information, we will consider whether there are any changes needed to the SIL governance document going forward, and give consideration to potential further allocations of strategic SIL and NSIL going forward. So that is a quick run through, Chair, of the report. Thank you.
Great, thank you very much for that update, Bryce. I'd be interested to know whether officers expect that with the revised SIL charging schedule, we're expected to be collecting more SIL overall than previously, or not?
What we can say is we will be collecting more SIL from the same amount of development because the charges have been increased. The amounts we do collect will depend on the amount of development which comes forward and the location in which it comes forward. But it is a positive thing that rates have been increased, and it means that we will be securing more money from developers towards infrastructure in the east of the borough.
Okay, all right, thanks for that. The other comment I had was, I mean, it's obviously very, very useful to have this list of projects to which SIL has been allocated, and obviously those projects don't belong to the planning department; they belong to but I think it's useful, you know, it'd be useful particularly to the public and also toward councillors about projects in their wards. But there are some that just I'm just not sure, you know. I mean, I'm looking at the Penstock Tunnel, for instance. It says project initiated and working underway. My personal experience of that, and I know you can't comment on that specifically, it's just an example, is there were some boards went up about a year and a half ago showing what was planned. Those boards have disappeared. There's been no further action since. So obviously this is no criticism of you, Bryce, or of Rob. I know that these projects don't belong to the planning department, but it might be useful to get a kind of more detailed update for people, because people will be asking about this. They'll be asking, where's this SIL money gone? So it would be useful to get a more detailed update about exactly what is the status of some of these projects. But obviously, you know, very clear that these projects don't belong to planning; they belong to the various departments that they belong to. Okay, Councillor Moyed.
Yeah, just on that table there, can I just double check? This is the Wood Green regeneration items, 6.1, 6.2, 6.3. You've said that the full amount is 34 million. It doesn't quite add up. Is that right, or it looks like there is some mistake?
I think that figure is indicating the total spend across the Wood Green projects, and then what we've provided is the strategic seal contribution as part of that overall spend. So giving you an indication of the element of the project which is funded by strategic seal. So in the case of Wood Green, the project's
I understand that. That's in the second. But even the full amount, it doesn't quite add up. It's not coming to 34 million, is it? Across those 3 projects.
Yeah, Councillor, Bryce was explaining the amount in the full amount column is the overall cost for the project. Strategic SIL is not the only source of funding for that project. There are other sources of funding which are not listed here. So the full amount column is the total amount for that project, which is in the capital programme. The SSIL contribution column is just the SSIL contribution. There are other pots of money that are going into this, which we have not listed here. We've focused on the strategic SIL element. I hope that helps elaborate on that.
I've understood that. I'm asking, is that the full amount? Is that the cost of those 3 projects? To me, when I add it up across those 3 projects, it doesn't add up to quite 34 million. I understand, you know, that figure represents other funding from other different sources.
I see what you mean now. So that figure of 34 million is the line that's in the capital programme under Wood Green Regeneration. The capital programme also has other Wood Green projects which are not listed here, and that's why there's the total amount. So I understand where you're coming from.
So that makes sense, because you've listed 3 projects. Those 3 projects are not 34 million pounds. Wood Green Regeneration, including other projects that are not listed in this table, may amount to 34 million pounds in total. Okay, all right, thank you.
Okay, thanks for clearing that up. Any more questions on this item? Yes, Councillor Hymas.
I'm wondering if you could just say a little bit more about the allocation of the neighbourhood SIL under the new formula. I appreciate I may have missed some of this debate for not being a councillor, but I was a little bit confused by the methodology. So if there could just be a bit of clarification, that would be really helpful.
The idea behind NSIL is that it's spent in the area which it's raised. However, there is a fundamental issue in Haringey, which is that rates in the east of the borough, until they were amended recently, were 11 times lower than the centre of the borough, and I think 14 times lower than the west of the borough. So for the same amount of development, you're getting 14 times less and 11 times less money in the east of the borough, which I think you would agree is fundamentally unfair since it's the same amount of development. So we looked at how we could bring about a fairer approach which more fully reflects the amount of development which has come forward in the borough. Now, I think you can dice and slice it a number of different ways. This was the particular format that we agreed at the time. So I'll just talk through it. Okay. So I think you start off with 100% of NSIL. 15% is allocated based on the amount of development in that area. So that's looking at the number of dwellings that have been delivered over a set period. Then a further 10% is allocated proportionally to Tottenham. So what this is doing is this is reallocating money towards the east of the borough, away from other areas of the borough, having regard to the fact that identified infrastructure needs are higher. And that is evidenced by the council's infrastructure evidence, particularly our infrastructure delivery plan. So that's moving more money to the east of the borough. And then finally, money is being divided up based on the number of wards in that area. So I guess the idea behind it is that the NCL amount reflects that the true amount of development in the area, that it's fair on that basis, but that there is a slight reallocation to wards in the east of the borough having regard to the slightly higher infrastructure requirements.
So if you had a development in Highgate, 10% of the NSIL would go to Tottenham.
Sure. Yeah. Sorry, it's a bit confusing. So For Highgate in particular, where there's a neighbourhood plan, that is ring fenced, but because of the legislation, we can't redistribute that. It is for the neighbourhood plan area. But say another area in the west of the borough that doesn't have a neighbourhood plan outside of Highgate, yes, in theory, yes, some of that is redistributed.
What's the process for getting a neighbourhood plan implemented, and why does only Highgate have one?
There are 3 neighbourhood plan areas in the borough. The only area which has proceeded to a plan is Highgate. The other 2 areas are also in the west of the borough, so we haven't had any take up from the east of the borough, and that's something we're looking at the moment in terms of potentially how we could better support people to bring forward neighbourhood plans. I think it's worth mentioning that they are substantial things to bring forward. It's not easy for the community to do so. The government seems to think it's an easy job, but it's not. So there tends to be more interest in areas of the borough where people might have more resource, more spare time. So that is a particular challenge around there. But in theory, there's no reason why neighbourhood plans couldn't be brought forward across the entire borough, subject to there being enough interest from the community. But the key thing here is that they should be community-led rather than council-led. So it's really about the community coming to us, telling us about their plans. Although to note, so we mentioned around the Levelling Up and Regeneration Bill, which is proposing some changes to the planning system. I think there is a recognition from the government that neighbourhood plans are unwieldy and difficult for some communities to bring forward on their own with limited support. And there isn't much support now in terms of funding available to them from the government. So they're looking at a scaled back approach, which would enable local communities to have important input, but more focused around their priorities and their vision for an area rather than the technical details such as would need to be contained within the neighbourhood planning document.
Just to clarify on that, because you've said that the neighbourhood SIL that belongs to Highgate can't be redistributed under that because they've got a neighbourhood plan. So if, let's say, the Northumberland Park area had a neighbourhood plan, would they only be able to use for that neighbourhood plan the NSIL raised there and not the stuff that's been redistributed from the west of the borough under our policy?
If there were to be a neighbourhood plan covering the Northumberland Park area, for instance, then 25% of SIL receipts in that area would be ring fenced for that area to spend in that area. The council could, as far as I'm aware, still choose to reallocate money from elsewhere, from other ends still collected, and would have to make a decision around that.
Okay, thanks for that. It does sound like if we were wanting to encourage people in the parts of the borough where significantly less SIL is charged, then we would have to make that explicit that we intended to allow that that redistributed NSIL to be used. But anyway, that's just a comment, really. If you'd like to respond on
if
that.
I've just add quickly, so I mean the starting point for bringing forward neighbourhood plan in most instances, we don't have parish councils, which you don't in London, is that you need to establish a neighbourhood forum. There's a couple of thresholds around that, but usually it's 21 people on the electoral register. So that's the starting point in terms of trying to get a neighbourhood plan moving, identifying 21 individuals who are prepared to sign up to the forum. There's then a process you need to go through to properly establish that forum, but that's what you're looking at to start off with. But of those 21 people, they need to be really engaged and have a lot of energy and focus to really get a neighbourhood plan moving forward, I would say.
Great, thanks for that. That's very clear. Okay, any more questions on this item? No. Well, thank you very much, Bryce and Rob and Councillor Carlin and you're free to leave now. We've just got the work programme to do. So thank you very much for sitting here and answering all our questions, and see you again soon. Thank you. Okay. Great. So work programme. So the items in the papers. Did you want to say something on this, Philip? I mean, we've just yeah. Go ahead.
Okay, so what you have in front of you, agenda item 11, is a report that basically sets out the process for developing the work plan for the Overview and Scrutiny Committee and the 4 panels that sit below it. In essence, section 4 sets out how the process, and I guess the key points to note here are that Overview and Scrutiny Committee have asked that a consultative scrutiny cafe event is set up. The date for that is the 9th of September. And it's likely to be held in the Sixth Form Centre, although this is still to be confirmed. The idea is that we're going to have a public event and invite community groups as well as councillors and other stakeholders, just to have a sort of discussion around where they would like to see scrutiny target some of their focus over the next 2-year work plan. Prior to that, we are going to hold an online scrutiny survey on the council's website, just to sort of engage people that way. So rather than necessarily having to turn up in person, we can consult people's views via that way. And then all of this information will be sort of sorted, condensed, and turned into a work programme going forwards, like I say, for over the next 2-year period. So I guess it's just to note that, really. And the second thing to say is that as our next panel meeting is the 29th of September, we will need some suggestions as to what you may like to see on the agenda for that, because we probably won't really have time after the scrutiny cafe to sort of feed that in. There isn't really enough time. So I guess it was just a request, a plea for a discussion as to, is there anything you would particularly like to see in the next agenda?
Great, thanks, Philip. So, okay, so the work programme for the next year or two is going to come out of this scrutiny cafe, but we need to decide what we're going to be looking at in our next meeting. Obviously, this evening we've had 4 reports that are basically updates on current council policy streams. They were all rather focused on Councillor Carlin's portfolio. I'm actually going to be meeting with Councillor Gordon at some point in the near future to have a chat about items in her portfolio that we might want to scrutinise. So obviously, in terms of setting the agenda for our next meeting in September, I'm a bit interested in hearing your ideas. Obviously, in addition to that, we've also made a decision this evening that we're going to be setting up a review into the council's private sector landlord licensing scheme. So we'll need to get together outside this meeting and have a chat with the other panel members that aren't here tonight as well about the terms of reference for that. So hopefully Philip will be able to set that meeting up in the not too distant future. So any ideas for items for our next meeting? Yeah, Mark, what would you like to say?
Yeah, I mean, I think from the previous meeting to this one, clearly the insourcing of Homes for Haringey, an update on that. I mean, we've had a member, was it an all-member briefing or was it a Labour member briefing? I can't recollect, but you know, I'd be hoping from September that some of the ideas and the kind of drive in terms of the priorities and what have you would be more established. It was all a bit woolly, quite frankly. At that briefing, I felt, and High Road West, which is I'm not great on the housing side of things, but I just appreciate sort of getting an overview in terms of where we are with that.
Okay, thanks for that. Philip?
Very quickly, if I read to you which bits, what comes under Councillor Gordon's portfolio, rather than, so I suspect the insourcing Homes for Haringey will come under Councillor Carlin.
Yes.
So in terms of Councillor Gordon's portfolio that's relevant to this panel, we have housing strategy and development, building high quality new homes, council house estate renewal, community land trusts, placemaking, and then property, and under property, council accommodation strategy, council property portfolio, and community buildings.
Okay, I do agree actually that we do need to bring the insourcing for homes for hire engaged. So I think maybe we have both cabinet members at our next meeting. Yes, Tammy.
One thing maybe is temporary accommodation. I don't know what, I mean, that comes under Councillor Gordon's portfolio, if I'm correct. Just speaking from experience and from some of the casework, a lot of the temporary accommodation that we provide is appalling. And I don't know if there's any way of, you know, looking into how the council, what the processes around that are.
I suspect that might be Councillor Carl.
Are we, are we talking about? So are we talking about the quality and the management of the temporary accommodation, or the management of our relationship with the providers of temporary accommodation, the policy under which people are put in temporary accommodation might not even come under the remit of this panel. I'm not sure. Would that come under adults and children?
No, I mean not specifically the ways in which people are placed into temporary accommodation, because obviously that's an assessment that's made by the homelessness team.
Yeah.
But I'm thinking more about how the council provides that, as you say, the relationship with the providers, as well as where the kind of acquisition strategy for those temporary accommodation sites.
Okay. All right. Great. That's something to work on, and maybe if we catch up on offline about exactly what that report will look like. Great. Thanks for that. Okay. Any other suggestions?
We need a general update on our housing delivery.
We can certainly get that. We had one at the last meeting of this panel, so that would have been in March. So we're talking 6 months. Yeah, do you think, is that reasonable? 6 months housing delivery? Why not? Eh? It is a key priority of the council.
Have we ever looked at the impact of the housing legislation? First,
I think just adding to that, I think just widening it a little bit as well as I think it's about how the council's discharging those duties, and I think this whole issue around I think that one in terms of the offer and the offer that you get private, you know, more and more private rented offers, I sense from casework, but also this issue about shifting people out of London, which I know was a big topic, but then kind of went a bit quiet. But I still believe that practice is still going on.
Okay, that this is a very big topic. It's certainly something that we all as ward councillors have experienced. Effectively, the way the legislation is framed in alongside the funding situation of the council basically puts us as ward councillors in the position of representing to our residents a council that is effectively forced to behave in an absolutely abominable way to some of the most vulnerable residents. How can we frame this as scrutiny, is how we look at it? What can the council do to avoid behaving in an absolutely appalling way to some of the most vulnerable residents, given the lack of funding and given the legislation that puts the council in that position?
To understand how we're dealing with the new landscape, the obligations that are in the legislation currently as it stands, and how we've been able to deal with any kind of new homeless families, and whether there are many people that have, you know, been put into private rented sector, but they've had to come back because they've not been able to afford the rent. Do we have any data on that? And what is our approach to those types? Because obviously the central government is telling us that as long as you just find them private rented accommodation, that's it, job done. But that can't be, that may be the legal position, but that's not always the moral position. Because if you're just putting a family knowingly that they can't actually afford the rent on the income that they have, and let's face it, private rented sector rent is very high. For a 2-3 bed, you're looking at £1,600 a month. A lot of people are not on that kind of, you know, salary, take-home pay per month. So this is causing a real problem to a lot of people. So we need to understand what's going on and what we can do. But then that will help us to maybe make recommendations to council, to the cabinet, to the executive, or to look at it as a scrutiny project.
Okay, and I would agree with that. And I would also add that I totally agree with that. We just need to make sure that we're not behaving in an absolutely appalling way to our residents. Oh, the other thing that I wanted to add is to describe a placement in the private sector as permanently housing someone is a bit of a joke, to be honest. Often temporary accommodation can be far more long term than housing in the private rental sector, given current tenancy laws. So to say that their council has permanently housed someone by finding them somewhere in the private rental.
The position is that the council has discharged its legal obligation as far as that homeless family is concerned.
Yeah,
according to legislation.
In terms of finding that person a permanent home.
Yeah,
that is how it's described.
Yeah.
And yet temporary accommodation is far more permanent than private rental sector. Sorry, Tammy.
Yeah, just to pick up on that discussion, I think that's a really important point, because obviously if we're forcibly discharging duty into the private sector, that doesn't necessarily help, because you can be evicted with 2 months' notice under current law. But I think it's also to say, when people are in temporary accommodation, how are the council engaging? Are they enforcing hazards, for example, that are in the properties? Are they enforcing, you know, landlords who aren't responding to emails or who aren't doing anything for repairs? And, you know, if suitability reviews need to be carried out, are the council carrying them out in a fair and, you know, open and transparent way about what people might need? That's the kind of angle which I think is important. Okay, clearly this is something that panel members are quite exercised about, so let's make sure that is an item for our next meeting. Okay, Philip, can I leave it to you to impose some order on our random musings ahead of my meeting with our agenda planning meeting? Okay, great. So I think that's us done for the evening, is it? Very good. Okay, it's 8:30. That's good timing, really. I'm quite.
Thank you.